Good morning students. Today we are learning joint stock company second topic. Joint stock companies, we are learn today here types of company. Types of companies, they are the four types of companies on the basis of incorporation, on the basis of number of members, on the basis of the liability of members, on the basis of control. They are the four parts of the types of company. First ones we are learn on the basis of incorporations. Statutory company, this company are incorporated by a special act passed by the central or state legislation. It means every joint stock companies, they are required to incorporated by special act by passport central and state legislation. For example, Reserve Bank of India, Units Trust of India, Life Insurance Corporation, State Bank of India, etc. There is the first types of the companies, statutory company. These all types of the companies are the statutory company. There are the collector license for central government and state government. There is company Reserve Bank of India, United States of India, Life Insurance Corporation, LIC, and State Bank of India, etc. Next, registered company. These company are incorporated under the Company Act 2013 or any previous company law. These companies are the registered company. These companies are here. There is a registration for the Company Act 2013 and previous companies law. Those all companies are said to the registered company. Those companies are registered for the Company Act 2013. Another types of the company on the basis of number of members. First, number of members, they are the first types of company, private company. Another ones are the public companies. Next one, the one person company. First, we are learn for the on the basis of number of company. First types of the company, private company. Section 2, subsection 68. The private company, section 2, subsection 68. Private company means a company having a minimum paid up capital as may be prescribed and which by its articles. That the minimum paid up capitals are paid those companies, the private limited company. There are the some prescribed for the articles here, restrict the right of member to transfer its share if any. There are the restrictions for the transfer of memberships. There is not easily transferable of shares in the private limited company. Next, restrict the number of its members up to 200. It means maximum numbers of members are allowed in the private limited company 200. Provisions, any invitations to the public to be subscribed for any security or deposit of the company. All the above said conditions should be fulfilled for a company to be called as a private company. All these conditions, three conditions are fulfilled, and therefore this company are declared for the private limited company. If one of the condition is not fulfilled by the company, it shall be considered as a public limited company. These three restrictions are not fulfilled. Therefore, these companies are declared for public limited company. It must add word for the private limited and at the end of that name. For examples are here Pragati Private Limited Company, Vora Packaging Private Limited Company. That types of the companies are here. They are the after companies names written for private limited. Those all companies are the private companies. A private companies may be a company limited by share or a company limited by guarantee or an unlimited company. That the first types of the company, private company. There section 2 subsection is 68. Another types of the companies are here public company. According to section 2 subsection 71, public company. Public company means a company which is not a private company. Those companies are not a private company. Those all companies are the public company. There are the restrictions here. A public company has no restriction on the transfer of share. It is easily transferable of share. Any person you can transfer for yourself for any time. It is a easily transferable of share. No restriction on transfer of its shares. There is the first provisions. Next, minimum number of members should be 7. At least 7 members are required in the public limited company. Minimum numbers of members should be 7. Has to have a minimum paid of share capital as may be prescribed by its article. Those mentioned in the public limited company article, this minimum paid of share capitals are required in the public limited company. Does not prohibit any invitations or acceptance of deposit from the public. This is the some provisions of the public limited company. Its companies are safe for the public limited company according to section 2 subsection 71. Another ones we are learn here. Third, numbers of company, one person company. According to section 2 subsection 62, a one person company is a company which has only one person as a member. Only one person is a member. There is no more than one person member. These companies, there is only one members are there. These companies are said the one person company. It is a private limited company and it has to fulfill and complete with all the formalities of private company. They are the all those ones we are learn here. Private limited company provision, they are the follow here unless otherwise specified in the act or rules. The concept of one person company has introduced through the Company Act 2013. It is operated by a single promoters. One person company, they are operating single promoter. One persons are the promoter who has a limited liabilities and the promoters liabilities are limited. One person company can have one or more directors. They are appointed, one or more directors are appointed for the one person company. Their members are single but their directors are appointed more than one members. There is no need to hold annual general meetings because there are no members are there. Therefore, annual general meetings are no held. There is no need to hold annual general meetings in one person company. We are learn for here on the basis of numbers of members. Another ones we are learn here on the basis of liabilities of members. First ones are here on the basis of liability of members. First, company limited by shares. Company limited by shares section 2 subsection 22. These types of companies have a share capital and the liability of each member is limited to the unpaid part of the face value of shares purchased by members. It means this type of company have to share capitals and the liability of each member is limited and unpaid face value the share purchased by the members. Thus, during the existence of the company or in the event of winding up, means the closing time, a member can be called up to pay a unpaid remaining amount. For example, share values are here the 10 rupees. They are only paid for the 2 rupees. Remaining amount 8 rupees are unpaid. That on 8 rupees they are the paid for the winding up. There is a pay for unpaid amount on the share purchased by him or hers. There is a company limited by shares. Another ones are company limited by guarantee. Section 2 subsection 21. These types of company may or may not have a share capitals. They may or may not have a share capital. Each member promised to pay a fixed sum of money. Every members are fixed sum of money specified in the memorandum. In the event of liquidations of the company, for the payment of the debts and liabilities of the company, they are the company limited by guarantee. Generally, such companies are not profit making. There is not a profit making or working for company limited by guarantee, because they are formed for the purpose of promotion of arts, cultures, charities, sports and other similar purpose. These all types of the companies, they are the company limited by guarantee, and they are started section 2 subsection 21. Another ones are unlimited liabilities company. Unlimited liabilities company section 2 subsection 92. A company not having any limit on the liability is termed as an unlimited company. It means the company not having any limits. There is no limit on the liabilities. Unlimited losses, debts, yours. In terms as a unlimited company. The members are fully liable to cover the debts of the company. Fully liable. All the liabilities are paid for the members. The unlimited company can be either a private or public company or a one-person private companies. These companies are say for the unlimited liabilities company. Section 2 subsection 92. Next, we are learn on the basis of control. On the basis of, there are two types of company. Holding company, section 2 subsection 46. A holding company is a company which holds more than one half of the total share capitals of another company, or has power to appoint or remove all the majority of directors of another company. They are say for the holding company. They are the hold for another company. There is a more than one half of the total share capitals of another company, and there is also appointed and remover for the directors, that power for another companies. There are the two company, A and B companies are here. There are the A companies are the members, and there is also holding for the B companies also, and there is all the powers are here. Next ones are here subsidiaries company, section 2 subsection 87. A subsidiary company is just the opposite of the holding company. It is the opposite to holding company. It is company which is controlled by a holding company. Such control is possible because the holding company purchases more than one half of the share capitals of subsidiary company, or has power to the appointed or remove all the majority of its directors. This is the on the basis of control. This once we are learned today here some types of companies. There are the four basis types of companies we are learned here. The first is on the basis of incorporation, second on the basis of number of members, third is on the basis of liability of members, and next ones are on the basis of control. Now assignment question, student, write the types of companies. Thank you students.